Hey guys, how's it going? Okay, I just wanted to go over this stand your ground thing one more time because it seems like there's a little confusion. So this is the layout. It's 776 justifiable use of force. Basically, we have two places where George would be protected, and then we have the immunity, which is 032. So he's got 012 and 013, which is going to protect him. Let me show you how. 012, use of force in defense of person. And if you look down here where it says however, so this is all about, you're allowed to protect yourself with your fists, or, you're allowed to meet force with force. So if somebody comes up and punches you in the arm, you're allowed to punch them back. And the police aren't going to arrest you for assault for defending yourself. And that, a lot of schools and stuff, they grab the kids, both of them, if they're fighting, and they both get suspended. Well, in Florida law, we don't allow for that. We say, if you're defending yourself, that's fine. No problem. And in this case, it says a person is justified to use deadly force. It has no duty to retreat if he believes that such force is necessary to prevent imminent death or great bodily harm to himself or others. And also anything that's permitted in 013. So we can see that he's protected here in this under the section 012 and under 1 and number 2, and I'll show you how number 2 fits. In 776013, this is the Castle Doctrine, and they went ahead and adapted this to fit as well. And I'll show you how. You can read all of this if you like. This is basically the, what happens in your house. And as you come down to number 3, it says a person who is not engaged in unlawful activity. So, the fact that George was walking around out there, he wasn't breaking any laws, and he's attacked in any other place other than his home. Because remember, this is all about your home. So any other place where he or she has the right to be has no duty to retreat and has the right to stand his or her ground and meet force with force, including deadly force. So a lot of people say, well, Trayvon wasn't armed and George was, so that's not force with force. But that's not true, and that's why they didn't say weapon for weapon, or otherwise they would have said, meet weapon with weapon. So, you have a knife, I have a knife, or if you have a deadly weapon with deadly weapon. But they didn't say weapon. They said force, and physical force can be deadly. And the answer to find out if it was proper use of force is to say, did George reasonably believe that he needed to use force that he assumed was going to be either seriously injuring to Trayvon or killing him? He knew that when he pulled the trigger. So the question is, did he reasonably believe that his life was in serious jeopardy or his great harm? So we can see that 013 fits on number 3. So that qualifies him. And if you come down here, you see in 031 if he would have come upon a situation where Trayvon was beating up somebody and he yells stop and Trayvon refuses to stop, he has the right to shoot Trayvon to make him stop. So that means that John, the witness that came out the door, if he would have brought out a gun and told Trayvon to stop and Trayvon refused, he would have had the right to shoot him, and he would have been protected under 031. So now we come up to the immunity portion of that statute, and you can see that it says anyone that uses force that is protected under the 012, the 013, or the 031 law is justified. So this is the immunity that says if you used deadly force as permitted under the laws 012 or 013, which both of those things apply to George, you are immune, and it says right here, is immune from criminal prosecution and civil for the use of such force. So there can be no civil prosecution if George qualifies for 012 or 013, then he immediately qualifies for 032 and is immune. All we have to do is go back and take a look, and we see that in 013, and we go down to number 3, we know that George was not engaged in any unlawful activity by walking around, even if he was trying to see where Trayvon went. And he was attacked in some place other than his home. He has the right to defend himself. He has no duty to retreat. He can stand his ground, and that's what the law says. He can use deadly force if he reasonably believes it's necessary to do so to prevent death or great bodily harm to himself. So that right there is enough to protect himself. That's it. And then we have the 012. And again, if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself, then he has the right to use deadly force. And that's what it tells us here, deadly force. So this pushes the prosecution into a situation where they're going to have to argue George wasn't reasonably in fear of great bodily harm or death. They're going to have to argue to a jury of 7 people. It's actually 6 is a jury in Florida, and then they have an extra in case somebody falls out, and convince these people that George was not in fear for his life when he was screaming and his head was being banged on the concrete. And even if it wasn't on the concrete, if it was on the ground, even if he was just pinned to the ground and this guy is pounding his face, that is enough. Any kind of serious injury like that, or it doesn't have to be a serious injury, it just has to be serious to the person who's on the ground getting pounded. There's no way the prosecution's going to be able to get 6 Floridians to agree that George was not in fear for his life at that moment when he was on the ground. Blood in his eyes, his nose broken, skin busted open in the back of his head. And the only thing that's stopping his skull from getting cracked open is the fact that he's still alert enough to use the neck muscles to keep his head from hitting the ground with all the force that it would if it, Trayvon probably was using his head like a basketball and just trying to dribble it on the concrete. But it was, you can imagine, try to push your head with your hands and use your neck muscles to push against it. And you can see you can slow it down quite a bit. When Trayvon reached for the gun, or at the very minimum when he said, "You're going to die tonight," that was absolute evidence. And at least George waited until all these things happened before he finally went for the gun. He was screaming for help. He kept thinking someone would help him, but no one would. And that's because people have become chickens in the world, Somebody should have come out there with a gun. I'm sure Trayvon would have got off and ran away. Anyhow, this whole point of this video was to rehash stand your ground, and nowhere in this law does it say anything about a judge in a pretrial. The Supreme Court has ruled on it in the past because of the fact that they left some openings like that, and the Supreme Court ruled that the jury still has in their control the question of immunity. Well, the Supreme Court Florida had ruled something along the lines, I can't remember the exact ruling, but they said that the courts, the fact that the judge gets to rule pretrial does not mean that the jury does not get the chance to rule on that. Let me see if I can find that real quick. All right, here you go. Scroll down here. So the trial court concluded that in acting 032, which is the immunity clause, the legislature did not intend to take the question of immunity away from the jury. So that means that regardless of what the judge rules, the jury, in the end, makes that final determination. I mean, we wouldn't, if you were in the position of possibly losing your life to prison, you certainly would want the jury and not the judge to make that determination. And that's what we do. So anyhow, good talking to you guys. Talk to you later. Bye.